week at NCA's Guide.
So good morning again, and thank you for joining the free introductory session to constitutional law put together by the NCA Guides. I'll start by introducing myself. My name is Seun Smith. I was admitted to the bar in Nigeria in 2012, I believe. And then upon relocating to Canada, I got admitted to the Ontario bar in 2021. And I currently work as a lawyer on the legal team of Mercedes-Benz Financial Services Canada Corporation. I have taught constitutional law for about 3 years now, and I also teach Canadian professional responsibility with Beauvais College. Beauvais College is a college located in Calgary, Alberta. Having said that, I'll get into our business for today. We are, I presume that everyone on the call is preparing or intending to write the Canadian constitutional law exams organized by the NCA. And the idea of this session, or the aim of this session, is to introduce the course to you, and then hopefully by the end of the session I would have been able to paint a big picture of the course to you. I also intend to highlight areas along the syllabus that I believe that you should pay attention to or focus on, and then I'm just hoping and looking forward to an engaging chat and a productive discourse or conversation with you all. So again, like I said, please pull up your outline. For all of your NC exams, you cannot study independent of your outline. And maybe just before we get into the outline, I should also speak to study materials. I received a couple of inquiries asking about, study materials. I mean, the recommended text is on the exam outline OGS. The syllabus was revised quite recently by the NCA. I believe it was revised in 2021, I believe. So please be mindful of that in your selection of, the text, the edition of the text you're going to use, and just generally whatever study materials that you decide to use. Also, before we get into reviewing the topics listed on the outline, I should also say that the NCA Guides offers paid intensive classes. So I aim to offer give 4 3-hour sessions running through the length and breadth of the syllabus, and also have an exam review session where we attempt sample questions or past questions on constitutional law. It'd be great to have you join my intensive sessions. Okay, having said that, let's go into the syllabus. Does anyone want to tell us what the first topic of the syllabus is? Well, the first topic in the syllabus. You go, Anudip. I should say thank you for turning on your camera and making me feel like I'm chatting with someone. And you look like you're about to go, but you're being careful. So please go ahead. You're muted.
Sorry, do I check under the scope of the subject?
Yes, the subjects. Yes, the subjects.
Just give me a second.
Sure.
First is sources.
Yes, so it'll be part 1, basic concepts. Do you see that, Anudip?
Basic concept. Yeah.
Yeah, is it? Yeah, part 1 is the introduction to the nature and sources of the Canadian Constitution, followed by an overview by the procedures for amending.
Yes, let's make sure that you're looking at the most recent syllabus. Are you looking at the most recent syllabus, Anudip?
It says revised for January 2022.
Yes, exactly. Yeah. Okay, so yes, the first topic on there is sources and nature of the Constitution. And just before we get into that conversation, I should try to introduce the course to you. And I won't overflog it because I assume, again, that everyone on this call is internationally trained and has at one point or the other had to study the constitution of a particular jurisdiction. And so whatever your recollection is of that, you know, of taking constitutional law in a different jurisdiction, it's essentially, you know, in terms of the concept and structure, maybe not concept, but in terms of the background and the structure, it's essentially the same thing. So this is the NC inviting us to study and understand the terrain of constitutionalism in Canada. And constitutionalism is, of course, as we should all know, a government or legal term that implies that a jurisdiction or a sovereign state is has put in place a grand norm being a supreme law that is the yardstick for measuring the legality of every other law enacted by the government as well as governmental actions. Does that make sense? So constitutionalism presupposes that a state has enacted and accepted a supreme law that is the foundation and the yardstick for measuring the legality and the correctness of every other subsequent law that is enacted by the government and governmental actions, as well as how governmental powers are exercised, right? So once you're invited to study constitutional law as a subject within a jurisdiction, then it almost presupposes the fact that constitutionalism is in operation within that jurisdiction. Does that make sense? Are we clear? And so that exactly is the situation in Canada. Canada has a constitution, or, you know, a set of documents that are referred to as the Constitution, by which governmental powers are regulated, monitored, and enactments or legislations that are enacted by the government are measured against. Does that make sense? And so what we're here to do is to review, you know, this collection of documents that make up the Constitution of Canada, review their stipulations, review their provisions in terms of governmental powers, the limits to those powers, and how those powers should be exercised. So unlike a lot of other legal subjects, like for instance, criminal law, that is majorly concerned with reviewing actions of citizens or the conduct of citizens and how those are measured or how those are held up against the law, which would be the criminal law, you know, in a jurisdiction. With constitutional law, it's the government, you know, loosely speaking, that is being reviewed. Is the conduct of the government, how the government exercises governmental powers, that is being reviewed. And so at the end of by the end of your study of constitutional law, you should have an in-depth understanding of the Constitution enough to be able to say that this action that was taken by the government is null and void because it isn't consistent with the Constitution. Do you appreciate that? Or this act, this law, this action that by any level of the government is constitutional or not constitutional, you know, in view of the relevant provisions or portions of the Constitution. So that's what we're here to do. We're here to understudy the Constitution such that we're able to, on the basis of the provisions of the Constitution, review and determine the constitutionality or the legality of governmental actions or powers. Does that make sense? Gominda, am I saying your name right?
Yeah, that's fine. Thank you.
Right. Does that make sense? Right. Good. So we will start with, you know, as you and Anude pointed out, the first chapter in the syllabus, which invites us to review the sources and the nature of the Constitution in Canada. And before we get into the sources, I like to talk about the nature. And essentially what you should be aware of there, what you should be paying attention to whilst you study, is the fact that whilst Canada practices constitutionalism, which presupposes that there is a constitution of Canada, there is a document, a law that is recognized to be the all in all, or the supreme law in Canada, that law isn't contained in one single document in Canada, unlike a lot of other jurisdictions that practice constitutionalism, right? So in Canada, there is a constitution, but that constitution is presented across a couple of documents. And if you all don't mind and you're interested in doing that, I invite us to read certain provisions of the Constitution as well on this call. So if you just open up another tab on your device and, Google or type the Constitution Act 1982. Anybody able to pull that up real quick, I'd invite you to please read section 52 of the Constitution Act 1982. And I mean, whilst you're at that, it'd also be great if you could pull up the Constitution Act 1867. We will read portions or sections from those documents on this call. Anybody has section 52 CA 1982?
Yeah, I can read it.
Yes, I have. Go ahead. It's okay.
I'm just
right.
trying
Please
to
go
look for
ahead.
it. Is it Part 7, General? The Constitution of Canada is supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is to the extent of the inconsistency of no force or effect. So then it gives us the Constitution of Canada includes Act 82, Acts and Orders.
Just before you go into before you go into that, and I will invite you to read that for us as well, but hopefully everybody's looking into the Constitution, or at least everybody heard what Gominda read out, and you see how sub 1 of 52, the opening statement there, introduces or establishes constitutionalism in Canada. Do you appreciate that? It is the supreme law, and every act that is not consistent with this supreme law will, to the extent of that inconsistency, be null and void. Remember that I said that constitutionalism presupposes a system of government that recognizes and accepts or adopts one supreme law that is the all-in-all and the measuring stick or measuring standard for all other laws as well as governmental actions. So hopefully you see how section 52 sub 1, which Gominda just read out, establishes constitutionalism in Canada, and then Gominda will proceed to continue to read, and you'd see what this document or what is included in the Constitution of Canada. Please go ahead, Gominda.
Yeah, the Constitution of Canada includes the Canada Act 1982, including this act.
Yes.
So yeah, so that means this act as well. The acts and orders referred to in the schedule, and any amendment to any act or order referred to in paragraph A or B.
Right. So essentially, you'd see, and can you read that again, please, Gominda? What the documents that it includes?
So the Constitution of Canada, for sure, includes the Canada Act 1982, including this act, the acts and orders referred to in the schedule, and any amendment to any act or order referred to in paragraph A or B.
Right. So we see essentially A says this document, right, which is the 1982 Constitution, right? We'd also see the Constitution Act, the 1867 Constitution Act. Just a minute, I'm trying to pull up my Constitution Act as well. And for the purpose of our conversation with the NCA, studying for constitutional law for the NCAs, we will only be concerned with the Constitution Act 1867, as well as the Constitution Act, the 1982, which we're reading from now. But there you see that 52 introduces all the documents, and I'd invite you in your private study to read through the schedule to the Constitution Act, the 1982 Constitution Act, just to see the documents or the other legislations that have been conferred with constitutional status. But for the purpose of the exams, your constitutional documents will be the CA, and by CA I mean Constitution Act 1867, as well as the Constitution Act 1982. Does that make sense? And so what we're going to be doing, or when you start a study, what should be at the back of your mind is, attempting to understand those two documents, right? Particularly, going through your syllabus sections that have been referenced or highlighted in those documents in the syllabus. So you need to understand those sections so that you're able to, if presented with a legislation, analyze and make a decision on the constitutionality of such a legislation. Does that make sense? Or if you're presented with a scenario that that relays a governmental action or governmental conduct, you're able to understand these two documents enough to be able to make a pronouncement or a decision on how consistent or otherwise these governmental actions or conduct are with the Constitution Act 1867 and the Constitution Act 1982. Are we good? Any questions thus far? Anyone? Are we able to proceed? And so in terms of the nature of the Constitution of Canada, you're able to infer from what Gominder just read that it is not contained in one single document, right? It's contained in all those documents that were listed out in sub B of section 52, right? And then it's also important that I highlight to you the fact that the use of the word includes, right, in that section of the Constitution. So Gominder had read and said the Constitution of Canada includes, and then there's a list. The Supreme Court has interpreted the word includes to mean that what is contained in the list that follows is not an exhaustive list, right? So as the jurisprudence is developed, the courts, the government are able to introduce other documents or other concepts, as we'll find, as we'll discover shortly, and confer constitutional status on those documents or those concepts. Does that make sense to you? So you need to appreciate that whilst the Constitution of Canada is written, largely written, it also includes some unwritten concepts that have been conferred constitutional status, and it is not contained in one single document. So have that at the back of your mind in terms of the nature of the Constitution of Canada, right? And then we move real quickly and I have a brief chat with you on the sources. Of course, as your basic understanding of the word source presupposes what feeds into the Constitution, where the Constitution is derived from. Does that make sense? And when you go to study, or when you start a study, you see a number of sources, but some that I find interesting are, for instance, court judgments, decisions of court. And you see how that alludes to just what I was saying earlier, to say that the word includes has been interpreted as a non-exhaustive list, and the courts have in their review of certain cases, in their decision in certain cases, have conferred constitutional status on certain legal concepts. Some of those would be democracy, rule of law, respecting minority rights. There's nowhere within all of the documents that have been referenced as, constituting a Constitution of Canada where Canada is declared expressly to be a democratic state, for instance, or a federal state, for instance, but those have been conferred constitutional status by the courts. So if you read secession, reference secession rights, which is one of the cases we'll study when we start the intensive classes, and we'll unpack it. You see how the court, in reviewing Quebec's need to secede from Canada, had pronounced, made a pronouncement that says that Canada is a federal state, Canada is a democratic state that respects, minority rights, at the same time respecting, majority rights. Does that make sense? You'd see as well where the Supreme Court confers constitutional status on rule of law, to say that even though the Constitution doesn't open up to expressly declare Canada to be a state where rule of law operates, but from their understanding of the way that the state has been governed, then rule of law is certainly a foundational concept to governance in Canada, enough to enjoy constitutional status. Does that make sense? Another interesting concept that I'd like to highlight whilst we talk about sources of the Constitution in Canada would be parliamentary privilege, for instance. Parliamentary privilege is essential that you review that, you appreciate or understand that, because again, as much as Canada practices constitutionalism and has a written constitution which differs from what obtains in the UK. Canada used to be a colony of, the United Kingdom, and still retains a lot from that colonial relationship, right? So there's a lot of governance concept or governance style that is presently in operation in Canada that was borrowed or inherited from Great Britain at the time, or from the United Kingdom. Do you see that? So whilst Canada practices constitutionalism and the Constitution is the supreme law, the Parliament comes right next after that. So unlike a lot of states where there's constitutionalism in operation, you find that there's a push to say all organs of government are equal. So the executive, the judiciary, and the legislature. In Canada, there is a quiet acceptance of the fact that the Parliament, ranks slightly higher than the other organs of government. Does that make sense? And whilst in practice, it's not a conversation of subordination, right? But in theory and in terms of structure, governmental structure, the Parliament subsumes, for instance, the executive. The leader of the Parliament is the leader of the executive arm of government. So it's difficult to establish a distinction between the Parliament or the legislative arm of government and the executive arm of government, because you have this essentially the same key players in both arms of government. Does that make sense to you? To organs of government. And I mean, whilst the judiciary is very separate and clearly, differently situated, they enjoy independence, and so they do not pander to the other two arms of government. Does that make sense? Now, the reason that is important for you to understand is that with parliamentary privileges, there are, as it sounds, privileges that the Parliament enjoys that have constitutional status in that they're not reviewable by provisions of the Constitution. Does that make sense? And when you start a study, you'd review cases, or when you join my intensive classes, we would unpack cases like the New Brunswick, AG of New Brunswick, and the Broadcasting Corporation of New Brunswick as well, where the Parliament there, or the legislature in New Brunswick, had insisted that sessions or proceedings on the floor of the House could not be televised by a broadcasting company. And the broadcasting company had sued the legislature to say, we have a freedom of expression. We should be able to access proceedings on the floor of the House, of the Legislative Assembly. But then the court had held that in the direct performance of the duties of the Legislative Assembly, the Legislative Assembly has a right, or enjoys the privilege, to not be reviewed by the courts or by the Constitution. Does that make sense? And so hopefully you appreciate how parliamentary privileges have been conferred constitutional status. And the reason they're conferred constitutional status is not because you were reading expressly on the pages of the Constitution, but because they are at par with the Constitution and cannot be reviewed using the Constitution. Does that make sense? However, the clause or the caveat with that is that those conducts or those powers must be exercised in the direct discharge of, the duties that the legislative assemblies would have. So anything that is not so closely situated with the constitutional duties of the Legislative Assembly would not enjoy that privilege and would be reviewable by the courts using the Constitution. And when you go to study, or when you join, the intensive classes, we will review all of the sources of, all of the things that inform or constitute or comprise of the Constitution of Canada. You have imperial state statutes, you have royal prerogative, and those are conversations we'll have. But for the purpose of this call, the intention is to just introduce them to you and highlight the fact that you kind of breeze through them. At least my recommendation is that you try to study them, unpack them, and understand them before you attempt your exams, if that makes sense. And then having said that, we've taken a look at the nature of the Constitution. We've also looked briefly at the sources of the Constitution. I believe we should move to Chapter 2, and Chapter 2 is the amending procedure for the Constitution. Now, you have to be very aware of the fact that these procedures are procedures by which the Constitution itself is amended. So not, for instance, if the Parliament of Canada enacts a legislation and decides to amend that legislation, for instance, the criminal law needs to be amended or the criminal code needs to be amended, we will not be looking to the Constitution for amending procedures to amend the criminal code, because that is an enactment of the Parliament. Do you appreciate that? So the Parliament is able to single-handedly revise and amend the criminal code. But when there's a need to review the Constitution itself, then we have to look at the amending procedures. The Constitution itself provides procedures for which the Constitution is able to be amended. And so, you know, in most cases, the Parliament is not able to single-handedly amend the Constitution. Does that make sense? Or a legislative assembly of a province is not able to single-handedly amend the Constitution. Amending the Constitution must comply with the amending procedures provided by the provided in the Constitution. And typically, my recommendation to my clients in the way that you should study Chapter 2 is to just go into the Constitution and read those sections by yourself. Read them out loud. In fact, I always recommend that you have them printed out and you go with them into your exam hall. So just go into the Constitution Act 1982 and start your reading from 36, section 36 to I believe about 48 or 45, right? 45. Just read it out loud. 45, right? Thanks. Just read it out loud. You'd see the procedures being presented from the general amending procedure, some but not all. You know, read it out loud. It's reading in plain English. But of course, if we have more time during the intensive sessions, if you join intensive sessions, we'd unpack them. There are a couple of case laws that I find very important, you know, that will aid your understanding of especially the first three amending procedures that we will unpack. You have Aaron Campbell going on there, and we will look into those cases, unpack them, and try to really, you know, understand and identify the situations or the scenarios that require which of the amending procedures. Does that make sense? But I won't dwell too much for too long on that on this session because we have very limited time. Again, when you start a study or if you join my intensive classes, read those sections of the Constitution themselves. Read it out loud. It tells you what the requirements for each procedure is and what situation or what context will attract what procedure. Does that make sense? Someone wants to tell us the third topic. Adela, am I saying your name right?
Yes, third topic from syllabus.
Yes.
1 moment.
Sure.
I think third one is that part 3 with Aboriginal rights and the Constitution.
Just a minute.
Distribution of legislative powers, I think.
So the third, yes, the third topic there should be, yeah, from part 2, and then you have federalism. Do you see that, Adela? Do you see that? Okay, so
part 2 is that distribution of legislative powers.
Yes.
Yes,
and
this is
then
part 2.
Right underneath that, yes, that's part 2, and then right underneath that you have the third chapter. So it's important that we understand the exam outline. I see this a number of times because you kind of study outside of the outline. You'd either be shortchanging yourself or wasting your time studying too extensively. I'm an advocate for studying extensively. If you attend my classes, we'll go through each topic, we'll open it up, look at a lot of case laws. So I'm an advocate for extensive study, but at the same time, you don't want to go way out of scope, and waste your time or your energy. So please familiarize yourself with the outline and let that guide you. Do you understand, when you study? So our third topic there is federalism. And let me speak briefly to the subhead of part 2, which is of legislative power. Again, when I was trying to brief parliamentary privileges, Parliament is not supreme. The Constitution is supreme, but you talk about governmental from the Parliament. When I was also talking to you about concept, I mentioned federalism, and I said to you that there is nowhere in the Constitution that pronounces Canada to be a federal state, but the import of sections 91 and 92 of the Constitution Act 1867, which take a look, legislative powers in Canada were divided between two levels of government. So we have arms or organs of government. That would be the legislature, the judiciary, and the executive. And then we have levels of government, right? In a lot of federal states, it will be the federal government and the state government, right? In Canada, it's essentially the same thing, but that the state governments are not, states are not called states in Canada. They're called provinces. Do you appreciate that? So we have the federal government and we have the provincial government. And so legislative powers, which are like the most important governmental powers in Canada, are divided between those levels of government. Do you see that? By the Constitution Act 1867. So the topics or items listed out that only the government at the federal level, only the parliament or the legislature at the federal level are able to regulate or enact legislations in relation to. Does that make sense? And there are also items or topics or heads of conversations that only the legislature at the provincial level are able to enact legislations in relation to. So again, for the purpose of our conversation, when I say parliament, I'm referring to the legislature at the federal level, and then legislative assemblies would be the legislature at the provincial level. So there is that distribution of legislative powers that was established by the 1867 Constitution Act that inevitably makes Canada a federal state, because again, a federal state, like we all would recollect, is a system of government where governmental powers are distributed or divided and exercised at separate levels, whether it's federal, states, central, regional, federal, provincial. Do you appreciate that? And so the operation of 91 and 92 of the 1867 Constitution Act essentially entrenches federalism in Canada, right? And so when you see Part B, open up and say distribution of legislative powers, that essentially is what is going on there. That is just you appreciating the fact that Canada is a federal state and legislative powers have been distributed between the two levels of governments that we have, which are the federal government and the provincial government. Does that make sense? And so the first topic under part 1 is federalism, which is essentially a conversation I've had to say that whilst there is no verbiage in the Constitution of Canada that expressly names or establishes federalism in Canada, the provisions of 91 and 92 of the 1867 Acts infers that Canada is a federal state. And if you all don't mind, I'd invite us to go to the Constitution Act 1867. Let's read at least the opening statement of section 91, and hopefully that better highlights or animates the point I'm trying to make to you. Are you there, Adela? Do you have it open up?
What are we reading now? Sorry.
So we need to read section 91 of the 1867 Constitution Act.
Okay, thank you. Sorry.
Sure,
Okay.
no, that's fine.
91. It shall be lawful for the Queen by and with the advice and the consent of the Senate and the House of Commons to make law for the peace, order and good government of Canada in relation to all matters not coming within the classes of subject by this Act, assisted exclusively to the legislation of the province. And
Right.
for
Right. So you see the opening, hopefully we're all looking at it. You see how 91 opens up and says it shall be lawful for the Queen through the House of Commons and the Senate, which is essentially the Parliament at the federal level, right, to enact legislations in relation to the peace, order, and good governance of Canada, and in relation to classes of subject matters that are now listed below. Do you see a long list of,
yes,
items? So you see all of those classes of subject listed out below 91 are, quote unquote, the federal government's portion or share of the distribution of legislative powers. Does that make sense to you? Now, if you would go to 92, let's leave all of the other, items listed under 91. Let's quickly go to 92 and as well read the opening statement of 92, and hopefully you're able to see, the powers that were also distributed to the provinces, to the legislature at the provincial level. Okay, please, Adela.
in each province, the legislature may make laws in relation to matters coming within the classes or subject next here
Listed below. Yeah. Listed here under, I believe is probably what it says. Do you see that? So 91, so it's kind of like a word, a cake or loaf of bread. We will call that loaf of bread legislative powers, right? The powers to enact laws in Canada. And then by the provisions of 91 and 92, hopefully you see how, a knife has gone through this loaf of bread. One half goes to the Parliament or the legislature at the federal level, right? And is listed under 91, all of the classes of the subject matters that the federal government is able to regulate and control and monitor and enact legislations in relation to are listed under 91. And then you go to 92, and 92 says, this is what will be lawful for the provincial governments to enact laws in relation to, and gives you, a list. Now, it's also essential that I highlight the fact or the use of the word exclusively. Do you all see exclusively, in at least in 92? So it's essential that you appreciate that this distribution or this division of powers, after these powers were divided, it's like dividing powers between Adela and, so ANADIP is the Constitution Act 1867, and then she comes in and sees Adela and Gominda. Essentially, I mean, if we're going to be more figurative, ANADIP would be the colonial master, because you need to appreciate that the Constitution Act 1867 was enacted for Canada by the Privy Council that was seated in England. Do you appreciate that? Because, of course, at the time, Canada was not an independent or a sovereign state. So the Privy Council enacts this document called the Constitution Act 1867 and says in Canada, in this region, this colony, all powers to enact legislation will be divided between Adela and Gominda. Do you see that? Adela is the parliament, so her portion of the powers expressly listed out in 91. And Gominda is the province, your portion of the power of legislative powers in Canada or in the colony. ANADIP lists out under 92. Do you appreciate that? And now ANADIP says, Adela, you've seen your powers. Gominda, you've seen your powers. These powers are exclusive to both of you. Now, what that exclusivity does is that Gominda cannot usurp Adela's powers. Do you appreciate that? And Adela cannot also say, oh, Gominda, you're my friend. We attended NCA Guys introductory class together. I met you, we chatted a bit. Can I quickly borrow your subsection J power? Do you appreciate that? So there's an exclusivity. The provinces have to enact within their competence, as provided for by 92, and the federal government has to, act and exercise its powers or enact legislations within its competence as listed out under 91. Do you appreciate that? And so one of the first tasks that you will be confronted with in your study of constitutional law in answering a constitutional law question is to review legislations for the purpose of determining the constitutionality of those legislation based on this distribution of powers, based on federalism. Does that make sense? To say that, so now Gominda has enacted a legislation. I, Seun, have now been invited as a constitutional law student or scholar to say, please review this legislation enacted by Gominda and tell us if Gominda had the rights or had the competence or the constitutional authority to enact a legislation like this one that she has just enacted. Does that make sense to you? And that essentially will be the conversation we'll be having, under judicial review on federal grounds. So once you hear judicial review, what that presupposes is that the judiciary is examining a legislation or a governmental action for the purpose of determining its constitutionality, for the purpose of determining whether it is consistent with the Constitution. That there's judicial review. Now, when you hear judicial review on federal grounds, what should come to your mind is the judiciary or the courts are reviewing a legislation for the purpose of ensuring that it has been enacted by the person or the level of government that had the constitutional authority or empowerment to enact that type of legislation. Does that make sense to you? So essentially what we'll be doing is, this legislation was enacted by Adela. Did she have the rights? Did she have, is this one of the classes of subjects that was listed under 91 for Adela to be in charge of? Or did she quietly usurp some of Gominda's powers? Does that analogy help you to understand it? So once you hear federalism, what comes to mind is that powers have been divided. The federal government has their powers, the provinces have their powers. And then once you, in the exercise of that powers, again, these are legislative powers, and legislative powers you will be using to enact legislations. Does that make sense? So you'll be reviewing legislations that have been enacted by the federal government or the provincial governments for the purpose of ensuring that they comply with the provisions of 91 and 92. Does that make sense to you, right? And to be able to do that, I mean, hopefully you appreciate that to be able to do that accurately, you need to understand these classes of subjects that are listed under 91 and 92. You need to be able to understand if 91 lists out, for instance, the opening statement says that the Queen, through the Senate and the House of Commons, is able to enact legislations in relation to the peace, order, and good governance of Canada. You need to be able to understand what is peace, order, and good governance of Canada, so that if Adela enacts a legislation and she says this legislation is in relation to peace, order, and good governance, we will not be hoodwinked. We'll be able to say, oh yes, we understand what peace and order and good governance in Canada looks like, and we see that the conversation or the provisions that are contained in this legislation are actually in relation to peace, order, and good governance. Therefore, it is constitutional because Adela has the powers to enact in relation to peace, order, and good governance, and this legislation is in fact in relation to peace, order, and good governance. Does that make sense? Or if Gominda enacts a legislation and says this legislation is in relation to property and civil rights, then we must be able to understand, what does property and civil right include? What does it mean? What does it, comprise of, for us to be able to make an informed decision of whether or not Gominda's legislation is in fact in relation to property and civil rights, which will make it constitutional because she has acted or enacted within our constitutional competence. Does that make sense? That essentially is the conversation of judicial review on federal grounds or under federal grounds, right? It really is, on the one hand, first understanding the Constitution and the language of the Constitution, the way that powers have been divided by the Constitution, and then picking up a legislation that has been enacted by the government, whichever level of government, understanding that legislation and being able to marry both by, measuring this legislation against the dictates or the provisions of the Constitution for the purpose of being able to declare that it is consistent or it is in alignment with the provisions of the Constitution. Does that make sense? just because I cannot see Gomindan and I'd ask if anybody wants to, if anybody wants to repeat what I've said to you, or if you get off of this call and somebody asks you, what is judicial review on federal grounds? And I know you will say first, I haven't started to study, but what else would you be able to, loosely or briefly describe or explain to be your understanding of judicial review on federal grounds?
So exclusive powers.
Yes.
So these are exclusive powers as per 91 and 92 of the Constitution Act 1867. So provincial government in its own realm of powers, it can enact laws, and those laws overall have to be consistent with their like powers, like how they're
The
divided.
items listed out on the
List like example, like property and civil rights, and then also like banking would be a subject which is not a power conferred on the provincial government, whereas it is conferred on the central government, or you can say the federal government, right? As per yes. So now like that is what I would understand by federal system of government.
Federal system of government. Now,
sorry, then now when they say review of those powers, when it comes to judiciary ensures that they could have overlapping on each other's powers. Like there are doctrines which enable them to not usurp on their powers, but then those would be considered what I think is valid power, like within their power they can do it. Like in the case of Western Bank, this is an Alberta case where like they started taxing them, the banks, like Alberta Western Bank, whereas Alberta legislature started taxing the bank, whereas banking is an exclusive subject of federal government. So they said, I don't know if I am wrong or right, but I think the decision was held that um, so long as it was just that it was not singling out. So that was a doctrine which was used, saying that it is not singling out a particular, like especially the banks, but they are kind of taxing everybody. I think that's what it was, or I don't know.
Absolutely. I let me speak to that. You sound like you have started to study, right? And you're on track, right? And I'll speak to it. My question was, how would you describe the task of judicial review on federal grounds? And you spoke to it to say that we need to, or the judiciary is saddled with the responsibility of ensuring that each level of government is enacting legislations within
their
distribution, within the powers that have been divided and distributed to them by the Constitution, right, by sections 91 and 92 of the Constitution Act 1867. And then you went ahead to try to, speak to exclusivity in the face of cooperative federalism, right?
Oh yeah.
To say that whilst exclusivity is recognized within the scheme or operation of federalism in Canada, such that there shouldn't be any direct or invasive usurpation of powers, that will be inconsistent with federalism as presented by the Constitution. Canada recognizes cooperative federalism, and there are instances of overlaps. Now, before we get there, and we will get there, and I will speak to the Canadian Western Bank case that you mentioned, let me stick with the syllabus and just in one sweeping statement state that, having spoken to Chapter 3 and try to describe to you or establish what federalism means, or the import of federalism, or how federalism is established and is operation, or is operating in Canada, the next couple of topics that are listed in the syllabus, very important, but are essentially just an invitation by the NCA for us to understand and be able to interpret the language of the Constitution particularly those classes of subject matters that were listed under 91 and 92. Does that make sense? So you see chapter 4, you see judicial review and principles of interpretation. And I've explained judicial review to you, and I've said that there is a presupposition that you're unable to review any legislation if you do not understand and if you're unable to interpret the language of the Constitution as well as the language of this impugned legislation whose constitutionality you're trying to determine. Does that make sense? And so you have principles of constitution that assist you to understand, or that assist the courts to interpret the language of the Constitution. And we won't get into that too heavily until we get into the extensive classes. But then you have chapter 5 to about, I believe, 8 or 9, listing out heads of powers. So if you go back to 91 and 92, there's a long list of classes of subject matters that, have been divided by the Constitution for the federal government and the provincial government. But for the purpose of studying for the NCA exams, the NCA has invited us to study, I believe, only about 5 of those heads of powers. So that contains, our review, or the extent of our review of the Constitution, or interpretation of some of those classes of subject matters. Do you appreciate that? And so the syllabus or the outline lists out these classes of subject matters, these heads of powers, that, in their opinion, we must be deeply familiar with. So you have property and civil rights, you have trade and commerce, you have peace, order, and good governance, and you have criminal law. And as you start a study, or when you come into the intensive classes, we'll unpack all of these heads of powers. But the good news is that for the purpose of the exams, you will only be tested on these 4 heads of powers. Right? You only be tested on property and civil rights, peace, order, and good governance, trade and commerce, and criminal law. Right? So in your study or in the intensive classes, we'll unpack them. I'll tell you for free now, trade and commerce is competent to the federal government. So only the federal government is able to, and if you go under 91, you see it listed out, right? Only the federal government is able, or maybe we should do a little exercise. Let's all go under 91 and 92 and try to figure out what is competent to the federal government and what is competent to the provincial government, going by the heads of powers that have been listed in the syllabus. Anybody wants to take that on? Which level of government is competent to enact in relation to property and civil rights?
So we read Constitution Act 1867.
Yes, just take a quick scan of the items listed under 91 and the items listed under 92, and tell me, where do you find trade and commerce? Is it under 91 or 92?
So provincial, this would fall under property and civil rights is under the provincial government.
So does that mean you see it under section 92?
92, yeah. I'm just going to go to 92 now. It says exclusive powers of provincial legislatures. It says subjects of exclusive provincial legislation. In each province, the legislature may exclusively make laws in relation to matters coming within the classes of subjects. Next, hereinafter enumerated, that is to say,
Yes.
one is repealed, then the second would be they can do direct taxation within the province in order to raise, revenue for the provincial purpose, borrowing of money on the sole credit of the province, establishment and tenure.
I'm hoping let me interrupt you,
Okay, sorry.
but it's a really long list. So I'm just hoping that we can focus on the 4 heads of powers that are listed in the syllabus. Do you see that?
Okay.
The 4 heads of powers listed in the syllabus are property and civil rights, trade and commerce, peace, order, and good governance, and criminal law. And I'm hoping we can do a quick scavenger hunt to be able to identify under which of the sections those 4 are listed out. Do you see? And if you take a quick look at 91, right, you see
trade and commerce
you'd
would come
see
under section 2 of 91.
Right.
Subclause 2.
91. You see trade and commerce under section 2. Exactly. That's exactly what I'm hoping that we do. And then we can go and see, we see the opening statement of 91 itself already.
Yeah.
So banking is not listed in the syllabus. It's important. I mean, it's great if you know it, but banking isn't listed as one of the heads of powers. Do you want us to take a look at the syllabus again? So you see the syllabus lists out from chapter 5. Yes, from 5 you have property and civil rights.
Yeah, property and civil rights. Yeah.
Let's go to the 1867 Constitution and try to track that down to see.
Sorry, a criminal law is on 91.
Exactly. And what does that tells us that tells us that criminal law being under 91 is competent to who? What level of government?
The
9127.
91 is list out what is competent to the federal government, to the parliament. Do you see that? So if you find criminal law under section 91, it means only the federal government is competent to enact a legislation in relation to criminal law. Does that make sense? Do you see the distribution now? And then we were also able to Gominda found trade and commerce force in regulation of trade and commerce 91.2. So that also tells you if it's listed under 91, it is competent to the parliament, the federal government. Do you see that? Now let's go search for
POG power. POG power is under 91 only. Yeah.
The opening statement. The opening statement says that the Queen, through the Senate and the House of Commons, should be, able to enact legislations in relation to the peace, order, and good governance. Right there, 91 as well. Federal government. Do you see that? So we've been able to identify 3 of the 4 listed in the outline, in the exam outline, as being competent to the federal government because they're listed on the 91. Do you appreciate it? And then, of course, if you go to 92, you'd find property and civil rights. So that tells you that property and civil rights is competent to the provincial government. Does that make sense to you?
Yes.
Right. So you hopefully we're also undertaking a distribution going on here. We picked out trade and commerce, who should be competent to regulate this, and we saw that under 91 the federal government is. So you see kind of like the assignment and the distribution going on. And then I was saying to you that topic 5 introduces judicial review and principles of interpretation, because you must be able to understand this language, the verbiage used by the Constitution, and also understand the legislation that is being impugned for its constitutionality, for you to be able to review and determine whether or not a legislation is consistent with the Constitution. And I'd say that, that took us to chapter 6 to 9, I believe, where we're looking at all those heads of powers listed under 91 and 92. And let me ask, just as trade and commerce sounds, yes, it presupposes commercial activities. So we're able to safely say that the federal government is competent to regulate or enact legislations in relation to the regulation of trade and commercial activities within Canada. But just using those 2 words loosely, trade and commerce, you would be grossly incompetent or not prepared to review a legislation for the purpose of determining whether it is in relation to trade and commerce. Does that make sense? And so it's essential that we understudy all of these heads of powers in relation to decisions of courts, cases that the court has been invited to interpret or explain what trade and commerce would include and what it will not include. What does property and civil right mean? Does property and civil right mean just, rights in relation to landed property, real estate, and civil right meaning maybe right to protest, civil liberties? We need the courts, or the courts have over the course of time in developing the jurisprudence made very important pronunciations or declarations on what all of these rights, all of these subject matters mean. Do you appreciate that? So we need to understudy them, review case laws. In XYZ case, the court interpreted that property and civil rights, Kreger, for instance, Kreger and Law Society of Alberta, I believe, the court decided that regulation of trades and professions would be competent to the provinces because trade and professions have been interpreted to be included under property and civil rights. If you don't have a decision of court in that relation or in that regard, it's impossible for you to sit down in your house on your desk and decide that the legal profession, for instance, will be regulated by the provinces, because in interpreting property and civil rights, legal profession will be interpreted as being part of property and civil rights. Do you appreciate that? So once you start to study this heads of powers, what you're looking for are case laws and decisions of court that support, the interpretation or the unpacking of some of these heads of powers. Do you appreciate that? So you go into the exam hall or you're in a conversation and there's a question that says, what level of government regulates the legal profession? You're able to confidently say that the provinces are not the federal government. The provinces, provincial governments are competent to regulate, the legal profession, because according to the court in Krega versus, do you see that? Give a case law there. The court held that property and civil rights will include the regulation of trades and professions within a province. So when you start to study those heads of powers, approach it that way. Ask yourself, what has the court interpreted peace, order, and good governance to mean? Right? In what case did the court, have the opportunity to unpack trade, order, and good governance? In what cases did the Supreme Court have the opportunity to define or describe or expand the scope of the interpretation of criminal law, for instance, of trade and commerce, for instance? And those are conversations that we'll have in the intensive classes. And if you choose not to join the intensive classes, when you study on your own, pay attention to those cases. Case laws, very important. Do not study or do not restrict yourself to only cases that are mentioned in the syllabus. In the entire syllabus, there's less than 10 cases mentioned. You certainly won't write your exams with just 10 case laws. So when you start a study, once you get to chapter 6, property and civil rights, ask yourself, what are the case laws here? What issues or what subject matters have the court pronounced to be included under property and civil rights? So that if I'm reviewing a legislation and this legislation is in relation to, for instance, corporate securities, how much shares can I buy in a company? If you go under 91 and 92, you won't see securities. Do you appreciate that? If you go under 91 and 92, I doubt you see insurance, for instance, right? But it's in you understanding those heads of powers and how the courts have over time interpreted them that you will learn that in Citizen Parsons, the court held that insurance is competent to the provinces under the property and civil rights head of power. Do you appreciate that? So that when you're reviewing a legislation that is in relation to insurance, you remember Citizens and Parsons, and you're able to say this legislation is in relation to insurance, and insurance has been interpreted to be competent to the provinces under their property and civil rights head of power. That there is the exercise of judicial review. Does that make sense to you? And that there is also the reason why you need to understand each of those 4 heads of powers. You need to really, understand all that the court has said in relation to property and civil right, trade and commerce, peace, order, and good governance, and trade and commerce, and criminal law, because you will get legislations that are in relation to regular topics, regular subjects that are not listed under 91 and 92. Because again, as much as this division of power is exclusive and exhaustive, you can appreciate that, it doesn't exhaustively itemize every possible subject or every possible situation. Does that make sense to you, to you ladies?
So insurance can never be a subject for the federal government?
Can you say that again, please?
I said, I was like, can ever be insurance a subject of federal government?
Yes.
If it has
for federally incorporated companies, right?
Yeah,
for federally incorporated companies, then it will be. But generally speaking, insurance is competent to the provinces. And so it's important that you review case laws, because it's in case laws that the court would have had the opportunity to say.
How about the treaty making powers?
Treaty making. That's a good question. Treaty making powers, all Aboriginal conversations typically are competent to the federal government, and that's a different conversation, because
I'm talking about, like, I understand from your point, like Aboriginals, making treaties like the Treaty 7, other treaties they had, like in BC and all. But I'm talking about the other treaties, like we do it with Mexico, with other.
Right, in terms of international treaties.
International treaties.
International treaties, again, because they concern Canada as a dominion, as a sovereign state, entering into an agreement with another sovereign state will ordinarily be within the Parliament's competence.
Yeah, but then so, there would be provincial government also having treaty powers, right?
Yes, the provincial governments having agreements with other states or other countries, but essentially, and then it will be a case-by-case review. But essentially, if it's a treaty that will bind or that will be binding on the whole of Canada,
oh yeah,
do you see that? Then Alberta is unable to make a treaty with the UN, for instance, for the whole of Canada. Does that make sense?
Thank you so much for clearing it.
You sound like you have started to study, or you studied extensively, right? But I'm happy to clarify your questions. So again, it's in the way that you understand. It's in the way that you understand it at a granular level. If it's a conversation that concerns the whole of Canada as a dominion, as a country, then of course a province is unable to make that decision for the entire country. And you need this understanding when you're also trying to understand the difference between, for instance, property and civil rights and trade and commerce. Do you see that? If it's trade or property or commercial activities that affect or concern Canada as a whole, then it will be trade and commerce. Yeah. But if it's trade or commercial activities that is intra-provincial, just within a province, right, then it will be property and civil rights and competent to the provinces, right? Now, Gomina, I'm going to, you're derailing me because you've studied, which is great. I mean, it's a good problem, but the intention with this session was, you go.
No, go ahead. Thank you.
Okay, but the intention of this session was to just introduce the course to people who have not started to study. Again, I'm absolutely happy to take your questions, but I'm also trying not to move off track too quickly, because for people who have not studied, your questions will not be beneficial because they haven't started to study. Do you see my point, Kominda? So in studying, when you started studying, once you get to chapter 6 and 6 to 9, then your concern is having as expansive or extensive an understanding of these subject matters as possible, so that when issues like this come up, like some of the questions that Gominda has asked, you won't find treaty making listed under 91 or 92. You won't find insurance listed under 91. You won't find corporate securities listed under 91 or 92, right? But it's in your understanding of some of these subject matters that you're able to see that in this case, the court has incorporated insurance under property and civil rights, essentially, and in some cases under trade and commerce. Do you appreciate that? It's in studying that you will know that the province's powers to enact regulations or legislations to contain the effects of COVID-19, for instance, or a pandemic or an epidemic, an outbreak, has been declared upon by the courts in XYZ case to be under, matters of a purely local nature, right? Under property and civil rights, or for the federal government under peace, order, and good governance. Do you see that? So it's essential, and I'm emphasizing that a lot so that you don't take it for granted when you start to study 6 to 9. You need to unpack it in as much detail as possible, right? Because it is when you understand that you're now able to review a legislation to say, this legislation is in relation to insurance, and insurance in XYZ case has been, assigned under property and civil rights. So therefore, this legislation that is in relation to insurance should be assigned under property and civil rights. And if it has been enacted by the provinces, then it is competent law, or it is constitutional law. Do you appreciate that? And that essentially, will be the conversation or the bulk of the conversation, the structure of the conversation that you'll be having on the judicial review judicial review on federal grounds. And there are a number of doctrines that, there's a lot of doctrines that we'll be reviewing, but very importantly, you need to understand the Pith and substance doctrine, the Inter-Jurisdictional Immunity Doctrine and the Federal Paramountcy Doctrine. When you go to study, you start to see them. Those are doctrines that assist you in your judicial review for the purpose of, ensuring that you understand the gist of a legislation and you're able to make a decision as to whether it was properly enacted or as to the scope of its applicability. Who should it apply to? So this is good law. The body that enacted it had the competence, had the constitutional authority to enact it. However, who should it apply to? Do you see that? Does that make sense to you? Who should it apply to? Right? And you
Can you
know,
take an
okay,
example?
I didn't want to talk a lot on it, but
Can
you guys
you,
look at
sorry, can you make an
exactly.
example?
Yeah, I will.
Like,
I will.
okay,
So let's start
you.
with the Pith and Substance Doctrine. So the Pith and Substance Doctrine assists in answering the question of the validity of a legislation. And the conversation of the validity of a legislation is essentially that, was this legislation enacted by the level of government that had the competence to enact it? Again, back to our Adela and Gominda example, it would be Adela's enacted this legislation in relation to maybe Adela is the parliament and she's enacted a legislation and she's titled it Labor Act, for instance, right? And then this Labor Act has been impugned and is before the court for the purpose of judicial review on federal ground. Somebody is saying that this legislation is not constitutional, is invalid because Adela doesn't have the constitutional authority to enact a legislation in relation to labor, right? Mm-hmm. So validity answers the question, was this legislation enacted by the level of government with the constitutional authority to enact such a legislation? I'll say it again in case you're taking note. The question of validity is, was this legislation enacted by the competent legislative body, right? If it was enacted by the parliament, was the parliament the competent legislative body to enact this type of legislation? And if it was enacted by the province, is the provincial legislative assembly the competent level of government to enact a legislation of this nature or a legislation in relation to this subject matter? And so to answer the question of validity, you always use your Pith and Substance Doctrine. And Pith and Substance Doctrine essentially says that for the purpose of determining the validity of a legislation, you need to determine the pith and the substance of the legislation. What is the most convincing, the most powerful, the most prominent conversation or subject matter that this legislation is in relation to? Mm-hmm. Does that make sense? For the purpose of determining whether legislation has been validly enacted, we need to know what the legislation is in fact in relation to, right? And loosely speaking, a legislation can be in relation to a number of subject matters. A law can touch on different, subject matters, but the Pith and Substance Doctrine says we will only make the decision of the validity of a legislation based on the most prominent feature of that legislation. So it won't matter that it touches on a few other issues incidentally or minimally. What will be concerned will be what is the strongest conversation that this legislation was trying to have. What's the most dominant feature of this legislation? So again, back to the Labor Act. If in reviewing or in reading through the Labor Act, we see, for instance, that the biggest conversation that the Labor Act is trying to have, or the biggest focus of the Labor Act, is just ensuring that, let's see, what example, ensuring that whilst employers are able to compel their employees to work, employees also have a right, for instance, to express or practice their religion. So maybe the focus of the Labor Act is, just conversations around restricting the scope of the powers of an employer in relation to employee in a way that allows the employee to have freedom of religion. Do you see that? Then we're asking ourselves, what is this in relation to? Right? Is this in relation to religion, or is this in relation to labor relations between an employer and an employee? And of course, it's an example. In real life, you'd have a full-bodied legislation with about 50 to 100 sections with interpretations, and you're able to read that and get the full gist of what the legislation is in relation to. And then after reviewing that, the court is of the opinion that this legislation is seeking to regulate employer-employee relations, is seeking to regulate employment relations. Now we have a subject matter in relation, a subject matter to describe that legislation. Then you take that subject matter ideally to 91 and 92 to say, where is labor relations listed out under 91 and 92? So that assists me to determine who should be competent to enact this type of legislation. Are you with me, thus far? Now you go under 91 and 92 and I guarantee you will not find labor relations.
It depends on the federal subject.
Understanding of this. Just a minute. And then it now depends on your understanding of the subject matters that are listed under 91 and 92. Because if you understand the subject matters that have been listed under 91 and 92, you will know, for instance, that the court has held that labor relations are included under property and civil rights.
Oh, okay.
Does that make sense? There's case law for that says that property and labor relations
Snyder's case.
Snyder, an electric commission. Right? You see why chapters 6 to 9 are very important. Do you appreciate that when you're studying? Focus on chapters 6 to 9. Focus on all the case laws that you see there. Read as extensively as possible. If you've studied your property and civil rights, you would have read Snyder, where the court was of the opinion that labor relations should be shelved under property and civil rights. Now, having that, knowing that, then you come back to your legislation to say, in characterizing this legislation, because the process of judicial review for the purpose of determining validity using the Pith and substance doctrine is a two-step process, characterization and assignment. In characterizing this legislation, which essentially just means trying to determine the most apparent characteristic of the legislation. Again, like I said, the most prominent feature of the legislation, and you have read it, you've reviewed it, you understand the legislation, and you have the opinion that the most convincing or attention-grabbing characteristic of this legislation is labor relations. Now you go to you've understood your property and civil rights, you know your Snyder case law, and you know that the court has said that employment relations is competent to the provinces under property and civil rights. Right? Then you come back here. You ask yourself, this labor relation or this company before me, is it a provincial company, or is this legislation going to affect or apply to provincial incorporations? You answer that in the affirmative. Then it's an easy decision for you to say, remember, this legislation was enacted by Adela. Adela is the parliament. It's an easy decision for you to say, Adela, you have no business enacting legislations in relation to labor matters, because that is competent to the provinces under property and civil rights on the strength of Snyder. You put your case law. Do you appreciate that? And you're able to conclude to say, oh, Parliament, this was improperly enacted, right? You didn't have the constitutional competence to enact this legislation. Therefore, this legislation is invalid. Does that make sense to you? In terms of the question of validity, again, it is just looking to answer the question, was this legislation enacted by the legislative body that had the competence to regulate the subject matter that this legislation is in relation to? So giving that example of Adela's legislation, Labor Act, Snyder, you understand your property and civil rights, you're able to decide that Adela didn't have any business enacting the Labor Act. The Labor Act should have been enacted by Gominda, for instance. Do you appreciate that? And that is the conversation of validity. Now, take note that the Pith and Substance Doctrine says we will not invalidate a legislation just because it touches on other subject matters that are, for instance, not competent to, the enacting body. So long as the major conversation that it was trying to have is in relation to a subject matter that is competent to the enacting body. Now, that is a conversation of validity. Then you move to the conversation of applicability. That's another way that a legislation can be challenged on federal grounds. And applicability, like it sounds, just says that I agree that the legislation is valid. I agree that, you know, in this case, Gominda has the constitutional authority to enact the Labour Act. Right? So if the Labour Act had been enacted by Gominda, it would be a valid legislation. It's good law. It's constitutional. It is compliant with the division of powers listed out under 91 and 92, as well as case laws. Do you appreciate that? But the challenge is that I don't believe that this legislation should apply to me. Remember, this is applicability. I don't believe that it should be applicable to me. And the question of applicability can only typically be raised by a select set of people. In this case, I'm, for instance, a bank. Right? Seun is a bank, Seun Bank. Remember that banking is listed under 91, so banking is a federal business. Banks are first and foremost answerable to the federal government, to the parliament. We saw banking under 91, remember? Banking is listed under 91. Now, so Gominda comes, let's say that Gominda is the province of BC, and she has a Labour Act, and we are all agreed on this call that a Labour Act is valid law because labor relations is competent to the province under property and civil rights as held by the court in the Snyder case. So it's valid law. I'm not challenging or contesting the validity of the Labour Act that has been enacted by Gominda. I'm just saying that I'm a bank, I'm regulated by the federal government, and so Gominda and her provincial laws should not apply to me. Does that make sense? Right? Now, again, with applicability, your applicable doctrine there is the Inter-Jurisdictional Immunity Doctrine. Inter-Jurisdictional Immunity Doctrine. I believe that should be maybe chapter on the syllabus. Inter-Jurisdictional Immunity Doctrine is chapter 11, and we'll come back to Paramountcy. Chapter 11. And as it sounds, interjurisdictional immunity, just from the sound of it and your understanding of English, interjurisdictional means that this entity or this person is answerable to two jurisdictions. You see, from international, more than one nations. Interjurisdictional, more than one jurisdiction. So banks are a fine example, and I'll come to that case law that you raised, Gominda, the Canadian Western Bank case. Banks are a good example because as much as they are federal entities, federally regulated, you know, undertakings, they are seated and situated within provinces, right? So you have BMO. BMO has banks in all the provinces in Canada. And so ordinarily, whilst they are answerable to the federal government, provincial legislations are also applicable to them. But they're able to claim an immunity to the extent that this validly enacted provincial legislation that would ordinarily and otherwise have applied to us is going to impair a vital part of our operation. And I'll give you a very mundane, very basic analogy. It's like a traditional family setting. You have the mom, you have the dad, you have the child. Right? Now, the child in this situation will be interjurisdictional because a child needs to take instructions from daddy as well as instructions from mommy. Do you appreciate that? So mommy says, eat your food. Daddy says, and make sure you drink water when you're done. The child needs to eat his food as well as drink water. Does that make sense?
Mm-hmm.
Right? So again, interjurisdictional entities are the children. The provinces are maybe the mummies, and the parliament is the daddy. So some entities are interjurisdictional in that, in fact, we all are interjurisdictional in Canada. If you pay attention or you think about it closely, you realize that, for instance, we pay taxes both at the federal level and at the provincial level. Do you agree? Do you agree with that? Right? We pay income tax. That's the federal taxing going on there. We pay sales taxes. That's provincial taxes. Do you see that? So you see that interjurisdictional nature of the relationship between the relationship between citizens and Canada generally. Some legislations, some regulations are federal, you have to comply with them. Some are provincial, you have to comply with them. So good examples are federally regulated undertaking banks. Banks are inter-jurisdictional. They're first and foremost federally regulated because banking is a federal concern, but they're also seated within provinces. So they're also, held, or they also have to comply with provincial laws. So because it's a BMO car, you cannot drive above the speed limit, for instance. The speed limit on a particular road within BC or Alberta is 80 kilometers per hour. You better be driving at 80 kilometers per hour, even though you're a bank and you're first and foremost answerable to the federal government. Do you appreciate that interjurisdictionalness going on there? Now, ideally, validly enacted provincial legislations will apply to banks, even though they're also, saddled with federal legislations because they're interjurisdictional. But at some points, they're able to infer an immunity to say that I agree that your legislations are applicable to me, just the same way federal legislations are applicable to me. But this is about to negatively affect a vital part of my business, of my operation. And so at this point, I have to ask for help. Do you appreciate that? So when you hear interjurisdictional immunity, what should come to your mind is a protection that entities that have nature are able to, invoke at some particular point. Do you appreciate that? And the indicator for that point in time where those type of entities are able to invoke that immunity is, first of all, when they're able to establish to the court or convince the court that the effect of a provincial legislation will impair a vital part of the operation. And that just essentially means it's going to negatively affect an important part of the operation, right? Or where it is threatening the essence of what makes them a federal entity. And I think I'm having this conversation is already very extensive, especially if you've not started to study. Right, but when you start a study, hopefully you remember some of these things that we talked about, and they will make sense to you. They'll be more animated, and so at that point, the court is able to invoke an immunity, to say, okay, whilst this provincial legislation is valid, it will not apply to you because you are interjurisdictional. Do you appreciate that? That there's interjurisdictional immunity. Remember, I gave you 3 points. I said that a judicial review on federal ground can take 3 forms. It could be to the validity of the legislation. And with that, I said the question of validity is a question of, was this legislation enacted by the appropriate arm of government, or a level of government, right? And I said that your operational doctrine, there is the Pith and substance doctrine. Then I said another form that judicial review on federal grounds can take will be applicability. And I said that the question of applicability is answered by the doctrine of interjurisdictional immunity, right? And I gave the example of, the daddy and mommy and child, scenario. Now, the third one is operability. And operability goes to the conversation of the operation of a legislation to say that, yes, the law is valid, but should it be in operation? And you would have that when there are 2 validly enacted legislations that have been enacted by both levels of government, both legislations are valid and both legislations are in force, right? But the conversation or the conversation of operability will arise when these validly enacted legislations are contradictory or conflicting. Again, daddy example, mommy says eat candy, daddy says do not eat candy. So dual compliance is impossible. If you obey mommy, you'll be disobeying daddy. Do you see? And if you obey daddy, you'll be disobeying mommy. So the question is, which of these instructions should be in operation? Which of these legislations should be in operation? Because remember, both of them are validly enacted, but there's conflict, and I'm unable to comply with both. And so the question of operability is answered by the doctrine of paramountcy, which I believe is chapter 10, I think. And what paramountcy suggests, like it sounds, is that the federal law would always be paramount, enjoy paramountcy over the provincial law. Does that make sense? So where the federal government has enacted a legislation that says go in relation to the same matter, and the provincial government enacts another legislation validly and says come in relation to the same matter, and you're able to establish to the court that both legislations are valid, but both legislations are conflicting, or the provincial one is frustrating the purpose of the federal one, then the government will invoke the doctrine of federal paramountcy and hold that the federally enacted legislation will be paramount the provincial enactment. Does that make sense? And I won't overflog this any further, because these are conversations that should be had at the intensive sessions when you have also started to study. Do you appreciate that? Saying all of this without when you haven't started to study is probably going to scare you away from the course, in fact, and that's not the intention of this call. But I'll just put it out there, give you these conversations or these thoughts that should form your backdrop when you start to study. These are the issues, these are the questions that we're looking to answer. And so when you start to study, keep asking yourself these questions. Is this legislation in this case law valid? Or what is the concern here? Is it validity or applicability, or is it operability? And once you've been able to identify what the concern is, also ask yourself what doctrine has been established by the court to address this concern. Also ask yourself when you start to study, what's the scope of each of this doctrine? At what point will the court be able to invoke this doctrine? At what point will the court refuse to invoke this doctrine, for an applicant? And that there is, generally speaking, the big picture in terms of federalism and judicial review on federal grounds. And then before we get into, if you look on the syllabus, before we get into charter grounds, we start to have charter conversations. Aboriginal rights is snuggled somewhere in between federalism and charter conversations. And for constitutional law, again, the focus is governmental actions. So we're going to be reviewing what powers the government has, the limitations to those powers, and how those powers should be regulated when it comes to the relationship of the government with Aboriginal people, right? We're going to be looking at how the court has, established a standardized test for Aboriginal people to be able to establish their rights, Aboriginal rights, and Aboriginal title, right? And we're going to be looking at what the government's conduct should be in the face of already established rights and title, and even yet to be established rights and title. How should the government, approach Aboriginal people in terms of their rights and their title? We're going to be looking at the import of Section 35 of the Constitution Act 1982, right? And how Aboriginal rights have been elevated and conferred constitutional status and protection. Does that make sense? And your case law there, when you start to study, please pay attention to R and Sparrow, pay attention to Van der Pith, pay attention to Seal Cotton. You cannot write a constitutional law exam question that is an Aboriginal right question without having a good understanding of those three cases at least, right? And with that, I'll move quickly to charter rights because we're running out of time. Again, just like we said with federalism, we established that the Constitution Act 1867 makes it imperative for the government to ensure that in enacting legislations, they are acting within the scope of powers distributed to them. When we come to charter conversations, when you hear judicial review on charter grounds, what we're doing again is reviewing a legislation, but more frequently with charter reviews, you would have governmental actions as well, not just laws, but actions of government agents or government officials, right? And how well those respect charter rights. How well governmental actions and governmental legislations respect charter rights, right? Again, the Constitution has provided for charter rights as established guaranteed charter rights. And you see that in the Constitution Act 1982. Right? Those are the first conversations, your first chapters. 1 to I believe 15 or 18 thereabout introduces all the charter rights. Right? Section 1 opens up and says, these rights are guaranteed and established and protected by the Constitution. Right? So these are constitutional rights. And I don't know about your jurisdictions, the jurisdictions where you studied law. Where I studied law, they were called fundamental human rights. So they're essentially human rights, your rights to life, your right to, expression, your right to be able to practice your religion, your right to not be forcefully or illegally searched and harassed by the police. Do you see that? So these are rights that citizens have, or Canadians, or people that are residents physically present on the soil of Canada have and enjoy. And we're being invited first to understand these rights, just like we've been invited to understand the heads of powers, remember, property and civil rights, trade and commerce. First, understand the charter rights, and then be able to review governmental legislations and actions for the purpose of determining whether those actions or laws are protective and respectful of charter rights. Does that make sense to you? And then, of course, whilst we review charter rights and have a conversation around judicial review on charter grounds, we will also have a conversation around the fact that even though these rights are guaranteed and protected by the Constitution, they are not absolute rights. Do you see that? They are not unqualified rights. And that is very basic. That is understandable. Yes, you have a right to life, but your right to life might be impacted by your decision and action to take somebody else's life. Do you see that? Yes, you have a right to liberty and freedom, right? And security, but your right to liberty might be impacted by your decision and action, to hurt somebody in which so that your right to liberty is limited. So whilst the Constitution guarantees this right, protects this right, is generous with this right, they are also not limitless or unqualified rights. They can be limited by the government. Do you see that? By legislation. For instance, the Criminal Code is just essentially one whole document that limits rights. Do you see that? But it's essential that that limitation is done within certain parameters. Do you see that? So it's essential that the government, in limiting those rights, is guided within certain parameters. So you have conversations around Section 1. These rights can only be limited in a free and, in accordance with in accordance as provided for by the law, in a free and democratic society, and in a way that can be demonstrably justified. So if the government is going to limit my charter right, then they must limit it in a way that is demonstrably justified, is provided by law, and is, allowed in a free and democratic society. So we have a conversation around Section 1. We have a conversation around the Oakes test. So when you study, please look for Aaron Oakes case law. Read it as extensively as possible, because it is in that case that the court lays down the Oakes test. That is the test for justifying the limitation of my right, or of your rights. Do you see that? So if the government has limited your rights, the government has to satisfy the court by establishing that test for the purpose of leading the court to the conclusion that yes, this person has this right. Yes, you, the government, you limited their right. Yes, we also agree that your limitation of that right is justified. Do you see that? So if someone commits manslaughter, and the criminal code sentences the person, or provides that the sentence for manslaughter is, for instance, life imprisonment, they first will start our conversation from this person has a right to freedom, has a right to be able to move freely, to liberty, right? Then we establish that this right to liberty has been limited by this jail term, or by this provision of the model code that is sentencing this person to life imprisonment. And then the government will say, yes, we enacted the criminal code and we are enforcing it. In fact, there is already a decision, a sentence of life imprisonment. This person is already in a jail, or in a cell, or in a prison. Then we are here to convince you, court, that this jail term that infringes this person's charter right is justifiable. And so the government will have to start to put up facts like this person committed manslaughter. And we need to ensure that, people feel safe. And this person is not going about killing other people. Do you see that? So we start to have those conversations as prescribed for by the test. And if the government is able to establish that test, all the legs of the test is there a reasonable and substantial legislative objective? In the manslaughter situation or example, it will be yes, safety. Do you see that other people need to feel safe within the society, and people need to know that if someone has the potential of killing somebody, that person is not living next door and roaming around the streets. So that's a legislative objective, right? The next leg of that test is there a rational connection between the measure that limits the rights and this substantial objective? So you say someone that's committed manslaughter should be sentenced to jail, a jail term or a life term. That is the measure that is limiting this person's freedom of right to liberty. What's the rational connection between a life imprisonment sentence and the objective of ensuring that people feel safe and are not living next door to somebody that has potentially killed somebody before? Does that make sense to you? And the government should be able to establish to say, if we take people like this out of the society and put them, in a facility where hopefully they're also being rehabilitated and all of those, and they also serve as a deterrent to other people, stopping them from killing people, then we're able to convince the other people outside or in the society that our society is a safe place and nobody's going to kill you. Do you see rational connection, right? Then you talk about minimal impairment. So yes, this person has done something, and this your life imprisonment sentence or measure, is that the best? Is that the most minimally impairing measure that you can come up with that will still be respectful of this person's right to liberty? Do you see that? Can we not tap him on the hand, for instance, and say, don't kill somebody anymore? Does that get the job done, as well as be respectful of his rights? So minimal impairment, and then proportionality, the weight of the offense. Is it proportionate to the measure that is limiting this person's rights? Does that make sense to you? So those are conversations that you would have, or that you should be thinking about, questions you should be asking yourself when you start a study. And certainly those are, conversations that you will unpack and review in very fine detail using loads of case laws if you choose to get my intensive classes. And then having the charter rights, the limitation to those rights, justifying limitation of those rights, then you come to remedies. So for instance, the government has limited my rights unjustifiably. How will that be remedied? Or again, back to the Labour Act conversation. Adela has enacted the Labour Act that should have ordinarily been enacted by Gominda. How is that remedied, right? For judicial review on federal grounds, again, back to section 91 and 92 of the 1867 legislation, your remedy there is contained in section 52, which we read. I believe it was Gominda that read it out loud to us at the start of the class, right? The Constitution of Canada is the supreme law of Canada, and every law that is enacted that is inconsistent with the Constitution is null and void to the extent of that inconsistency. That there takes care of the conversation of legislations and enactment. Who should enact what? Did Gominda enact within a competence? The Parliament enact within its competence? Section 52 is your remedy. Now, there's a whole lot of conversation that will be had because the courts in interpreting section 52 have come up with at least 5 different variations of a declaration of nullity. Do you see that? Those are conversations we would have. And you also have to pay attention to the case laws in which the court, establish some of these variations or some of these remedies. Now, for charter rights, judicial review on charter rights, the government has, sentenced this person to a life term, a jail term that is, for life. And the court is of the opinion that this limitation is not justifiable. So what do we do? What's the remedy available for this person with this sentence that the court has held is unconstitutional because it offends, section a particular section of the Charter of the Constitution Act 1982. What's the remedy? Your case, your statutory reference there is section 24. And as a way to wrap up our conversation, I'd invite somebody to read section 24. Let's read section 24. We already read section 52. Let's read section 24 and then we conclude. Still have your Constitution Act 1982. still here with me on the call? Anybody find section 24, please read it out to us. Section 24, Constitution Act 1982.
Is it under enforcement?
Yes, 24.
Okay, I'll read it.
Section 24.
Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Do you want me to read too?
Right. So you see it's fine. So you see with charter infringements that are not justifiable, 24 is your constitutional provision in terms of remedy. And it says that you can apply anyone whose rights under this constitution or under this section of the constitution have infringed, I will add it in a way that is not justifiable, right? Then you can approach a court of competent jurisdiction for the purpose of obtaining a remedy that is appropriate in the opinion of the court. Do you understand? Do you see that? So for 24, and I mean for charter infringements that are not justifiable, the remedies in terms of remedy for infringement, the court has a wider jurisdiction. Do you see that? So that the court can, on a case-by-case basis, review a case, decide first that yes, you're entitled to that charter right. Yes, that charter right has been limited or infringed. No, the government was unable to convince us that limitation is justified or was justifiable, right? And yes, you're entitled to a remedy. And in the court's opinion, in this situation, this is what you should be entitled to. And it's a wide range. It could go from a public apology to a reversal of a sentence to compensation to damages. Do you see that? So 24 is a lot more wider, in terms of the remedial actions that the court can take is more wider is wider than section 52. Does that make sense? And I believe we've gone through, loosely speaking, the length and breadth of the syllabus from nature and sources and amending procedures to part B, which is essentially judicial review on federal grounds. And I highlighted, try to describe what the task of judicially reviewing legislation for ensuring its consistency with sections 91 and 92 of the Constitution, what it would look like, right? I also need to be super familiar with those heads of powers, those four that are listed in the syllabus: property and civil rights, trade and commerce, criminal law, and peace, order, and good governance. You need to be super familiar with them. You need to have all the case laws that are relevant to them. And then I also took you through those doctrines, the forms or the way that a legislation can be challenged on federal grounds. Validity. Validity is this legislation was not properly enacted because it was not the legislative body that enacted it doesn't have the competence or the constitutional authority to enact it. And I said that the way that you review that or you resolve that is by the doctrine of the Pith and substance doctrine, so that you're not distracted by the tiny other conversations that the legislation has, but you're focusing on the most prominent feature of the conversation, or rather of the legislation. And if the most prominent feature of the legislation is competent to the enacting body, then the law is valid law. Vice versa, if it's not competent to the enacting body, then the law is invalid and will be struck off, right? Will be declared unconstitutional. And then I said the second way that the legislation can be challenged on federal grounds is applicability. And we had the conversation of inter-jurisdictional immunity, to say that inter-jurisdictional entities are able to invoke that immunity when a provincial or, in the alternative, a federal legislation is going to have the effect of negatively affecting a vital part of the operation. And we also talked about operability. And I said that operability essentially is a situation of mommy said, daddy said. Dual compliance is impossible because the Parliament has validly enacted a legislation in relation to a subject matter, And the provinces have also enacted a legislation validly in relation to the same subject matter, but both of them are conflicting. Or the provincial legislation was drafted in a way that frustrates or that will frustrate the purpose of the federal legislation. Now, you have a right to approach the courts to say, I'm in a fix here. I'm not sure what to do. If I obey the federal legislation, I will be in breach of the provincial legislation. And if I comply with the provincial legislation, I will be in breach of the federal legislation. What do I do? And I also said to you that the doctrine that assists the court in resolving, the issue of conflicts between two valid legislations, validly enacted legislation, is the doctrine of federal paramountcy. And I told you that essentially what that means is that the court will hold that the federal legislation will enjoy paramountcy over the provincial legislation. So the provincial legislation will be valid but inoperable. So it's a good law, it's valid law, but it's kind of like frozen, right? So that the federal law can be in operation. Then we talked about Aboriginal rights. I gave you case laws that you should pay attention to, because in those cases, the court established a standardized test that will assist Aboriginal peoples to establish their rights, their title, and their rights when it comes to treaties, their treaty rights, right? And I also told you that we'll be looking at what the expectation is in terms of the government's conduct or the government's approach to Aboriginal rights, title, and treaty rights, where they have been properly established or where they're in the process of being established, right? Then we move to judicial review on charter grounds. And I told you again, essentially, that what we're doing there is ensuring that the government is exercising its powers and drafting or enacting legislations that are respectful of charter rights, right? And you see in the syllabus the charter rights that we've been invited to study. I believe you have the right to life, liberty, and security of person, freedom of expression, freedom of religion, and equality rights. Those four. You need to understand them, read them, get all the relevant case laws, have a good in-depth grasp of what the court has interpreted all of those rights to be, right? Then you should also be able to identify when either one of those rights has been breached or limited, which should be easy, right? But the bulk of the conversation will start where you're trying to now justify that limitation, because you understand that even though these rights are constitutional rights, they are not absolute rights. They can be limited where it can be demonstrated, where that limitation is demonstrably justified, and prescribed by law in a free and democratic society, right? And then I told you, about section 1, recommended that you read R and Oakes, because it's in that case that the court laid down the Oakes test that assists the government to justify a limitation of a charter right, right? And then we wrapped up by reading section 24 that talks about, I referred you to section 52 in terms of remedy for judicial review on federal grounds, and section 24 in terms of judicial review on charter grounds, partly because for judicial review on charter grounds, you would have both sections in play there. You would have section 52 in play as well as section 24 in play when you're talking about remedying an infringement of a charter right that has been held to be unjustifiable. Hopefully, this assists you when you go back to study. Hopefully, it gives you an introduction into the course and what the expectation is, or what thoughts and conversation you should be having when you start to study. And hopefully, I'd see you at my intensive sessions where we'll be having more detailed conversations about each of the chapters and doing an in-depth review of the case laws that I consider very important, given what topic or what chapter that we're reviewing. And that will be it for today's session, in the absence of any questions. But I'm happy to take your questions. If you have questions or comments or just need clarifications on anything, then now will be the time.
Yeah, I just had a question about the classes. So will you also teach us how to answer the questions step by step and everything?
Yes, so we will have, at the end of the intensive sessions, we would have an exam review session where you'd be presented with or we would attempt to answer a question together, one or two questions together. And, I will walk you through how to present your thoughts, in terms of the structure, what should come before what and what should go where. So yes, there will be that.